Hi. In this video we're going to explore and discuss some of my Republican opponents' positions, claims, actions, and views during this race. So let's just get to it. In the August 28th Sunday edition of the Reno Gazette-Journal, Mark Amodei wrote, and I quote, "Holding public office is a privilege, and I take that responsibility seriously. In order to be effective, you must have integrity, honesty, and tell people the truth." Well, we're going to tell people the truth in this video, and you may be surprised. So, let's start off with the first subject at hand. On August 10th of this year, Mark Amodei and myself were at the Stillwater Firearms Association meeting in Fallon. When he was introduced as being an infantry officer in the military during his 4 years. Well, according to the paper, he wrote, "During my 4 years of active duty in the U.S. Army, I served as an assistant U.S. attorney and assistant post-judge advocate." I'll let you draw your own conclusions on that one. Was he an infantry officer or just another attorney that was wearing a U.S. Army uniform? And what about that 4 years mark? Most officers spend at least 6. Okay, let's move on to a somewhat more important issue. We all know that the Republican Party filed a lawsuit in the end of May challenging the Secretary of State's decision on how to run this special election. The mainstream media did report to some degree what the circumstances were. They also reported about the disclosure requirements and the fact that Judge Russell and Mark Amodei owned a mining claim together and that they were in that firm. But it goes a little bit deeper than that. We know that the Nevada Republican Party was a plaintiff in the lawsuit. We also know that Mark Amodei was the chair of the Nevada Republican Party at the time of the filing. Now, what's important is the fact that if you look at the filing, which I have right here, I can show you, there's an operable word, and that operable word is "and." So it indicates that the Nevada Republican Party was a plaintiff in the suit. And that's further supported, if you follow the documentation trail, when it was appealed to the Nevada Supreme Court. In fact, the header on that document includes the word "and" as well. This is where it becomes a little sticky. We know that Mark Amodei is a licensed attorney in the state of Nevada. We also know that he was the chair of the Nevada Republican Party at the time of the filing. But what a lot of people don't understand is that there are rules that attorneys must follow. And those rules are called the Nevada Rules of Professional Conduct. When you start to investigate this entire case, you start to realize that there was something left out. There are some fine nuances that the media didn't tell you about. And some of those nuances actually are very important. Like I said, Mark Amodei was an attorney in this state, a licensed attorney in this state. The rules clearly lay out on what the obligations are of an attorney in many circumstances, including this. Rule 1.13, Organization as Client, states, "A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents." If a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in an action, intends to act, or refuses to act in a manner related to the representation that is a violation of a legal obligation to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. Rule 3.3, candor towards the tribunal, says, a lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Which means Mark Amodei had a duty to disclose, and he knew this. But then you go on to other parts of the rules. Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited by Rule 1.6. Then on to Rule 8.4, misconduct. It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, and engage in conduct that is prejudicial to the administration of justice. I can honestly say this much. The Nevada Rules of Professional Conduct clearly lay out that Mark Amodei and the judge should have disclosed this type of information. But as you can tell, I'm not an attorney. But just because I'm not an attorney doesn't mean I can't comprehend what I read in the law. I understand much more about disclosure than the average person. Remember earlier in the previous video, I said that a law firm had conducted themselves in a similar manner? That was on the issue of disclosure. So I do know somewhat more than the average person because I've researched it. In fact, Mark Amodei may want to look into some case law history out of the state of Nevada as well as the U.S. Supreme Court. A case was decided in the Nevada Supreme Court in October of 2009. That case was NC-DSH Inc. v. Gardner, which they talk about disclosure. There's also another case that was decided in the United States Supreme Court. That case site is Caperton v. Massey Coal Mine. That too went to the issue of disclosure, both by a judge and the attorneys. But what is more important is that this type of conduct is what one would call as fraud on the court. And fraud on the court is defined under the Black's Law Dictionary as being a lawyer or party's misconduct in a judicial proceeding so serious that it undermines or is intended to undermine the integrity of the proceeding. Well, when you have a pecuniary interest with the judge, as well as a professional relationship with the judge in a previous law firm, that starts to show that there is an issue of disclosure that must be addressed. Yet neither one of them said anything. And Mark, being an attorney in the state of Nevada, understands these rules. He should understand the Nevada Rules of Professional Conduct as well as the Nevada Rules of Civil Procedure. And that is where I believe it is important in this case. He does have a duty to disclose, without a doubt. And he should have, but he didn't. So again, I'm going to have to let you be the judge on this one. When he wrote in the paper that you must have integrity, honesty, and tell the people the truth, how does that reconcile with this issue? There's no question in my mind that Mark Amodei is not showing a level of honesty and integrity in disclosing to the people what the facts are in this case. I also believe that he's banking on the people's lack of understanding the rules that I just provided for you. Is this the type of conduct we want representing us in the U.S. Congress? Again, You'll have to decide. Thank you.